Hi everybody, I'm Steve Vladeck, professor at the University of Texas School of Law and author of the forthcoming book, The Shadow Docket, How the Supreme Court Uses Stealth Rulings to Amass Power and Undermine the Republic, due out from Basic Books on May 16th. For those who don't follow the Supreme Court that closely, we're reaching the home stretch of the court's annual progression of decision-making. Every year, the Supreme Court hears somewhere between 60 and 70 cases, and sometime in April, May, or June, it hands down lengthy, often divisive opinions. As we reach the end of April, though, the Supreme Court's actually pretty far behind in getting to these decisions. So far, the court has handed down only 13 rulings in argued cases. We expect at least 45 more between now and the justices' summer recess, which usually begins around July 4th. And in addition to affirmative action, there are other hot-button issues on the docket, including racial gerrymandering, including whether business owners can discriminate against same-sex couples in the provision of wedding websites and other services, and a whole litany of other important issues. Part of why the court is behind, though, is actually a big part of the book that I have coming out on May 16th, which is the rise of what's known as the shadow docket. The shadow docket is an evocative shorthand for that part of the Supreme Court's work other than these 60 to 70 high-profile merits decisions that the court hands down every term. And one of the things that I talk about in the book is how in the last 5 or 6 years, the shadow docket has come to play an ever larger part of the Supreme Court's workload. We're seeing more and more cases that are getting to the court this way. We're seeing more and more decisions that are having huge impacts on large swaths of American society. And like is the norm for orders from the Supreme Court, the vast majority of these rulings are unsigned and unexplained. The latest one of these rulings came on Friday, April 21st, when the Supreme Court, in an unsigned and unexplained order, put back into effect the access to mifepristone, also known as RU-486, an integral part of medication abortion that had been blocked by a federal district judge in Amarillo, Texas. A judge in Amarillo had said that the FDA's 2000 approval of mifepristone and a series of subsequent rules from the FDA that had made access to mifepristone easier were all unlawful, and so blocked them under federal administrative law. The government and one of the sponsors of mifepristone, Danco Laboratories, first asked the federal appeals court to intervene. The appeals court intervened in part, but not really in full. Then they went to the Supreme Court. And what we got on Friday night was actually pretty typical of shadow docket rulings. The majority offered no rationale for why they were putting the lower court ruling on hold. They offered no analysis for what should happen to this case going forward. All they did was to preserve the status quo, was to issue something called a stay pending appeal. That basically means that Judge Kaczmarek's ruling, the district court in Amarillo's ruling, can't go into effect until the case comes back to the Supreme Court at the far end of litigation, and the justices have a full opportunity to rule on the merits. What's striking about Friday night's ruling is actually that although it's deeply consistent with how the Supreme Court approached these issues historically, it's pretty inconsistent with how the justices have behaved in recent years. Since 2017, we've seen a huge uptick in the context in which the justices are intervening to disrupt the status quo, context in which the justices use unsigned, unexplained orders to actually have massive effects on the ground compared to where the law was previously. Just to take a couple of cases in point, the SB 8 case in Texas, where the court refused to block Texas's controversial 6-week abortion ban from going into effect, a ruling that made abortion effectively unavailable in the nation's second largest state 10 months before the Supreme Court would formally overrule Roe versus Wade in the Dobbs case. Lots of Trump-era immigration policies that lower courts blocked because they were purportedly unlawful, from asylum rules to the travel ban to the border wall, put back into effect through unsigned, unexplained orders by the Supreme Court. And so one of the things that the book tries to document is how the shadow docket, the sort of stealthy way in which the Supreme Court decides these kinds of emergency applications, the way the court controls the merits docket by deciding which cases to hear and which issues to resolve within those cases. All of these points are such a vital part of understanding how the Supreme Court as an institution operates today. Indeed, it is really impossible to understand what's going on at the Supreme Court without understanding what's happening in the shadows. And so as we come toward the end of the Supreme Court's 2022 term, keep in mind that this is just one slice of a much larger pie, and that the pie, the Supreme Court as a whole, is an institution that operates principally, if not almost exclusively, behind closed doors in ways that we, the public, often cannot see, and it's not easy to understand. And so I hope that as you are paying attention to what the Supreme Court does between now and the end of June, as we get these big merits decisions, keep in mind that this is not just a small piece of what the Supreme Court does, but that understanding how the court came to play such a dominant role in our contemporary society, how it came to be the fulcrum for so many of these vital social policy debates, is something we really can't fully understand without putting into proper historical context what happens in the shadows. Thanks very much, and stay tuned.